5, 4, 3, 2, 1. At the very threshold, it must be said that, though I have devoted deep and anxious consideration to the issues herein, it is my fond hope that the ratio of this judgment may prove to be truly ephemeral and at the earliest be relegated to the dead past full stop. As is manifest, the issues herein arise entirely because of inevitable but nevertheless grave delays in the hearing of appeals in capital offences within this court full stop. The moment such appeals can be heard with just expedition as they should be, the question herein would obviously evaporate into the thin air full stop. With some justifiable pride, it is to be recalled that right till the close of the year 1981, even murder appeals preferred in the year 1969 and well beyond a decade were still pending disposal full stop. Fortunately, these delays have been emanated in their entirely within the jurisdiction of the Ranchi bench of this court, where appeals filed in the current year itself are now being listed and disposed of full stop. But for the fact that the court has remained crippled by the absence of full one third of its sanctioned strength and as many as 13 vacancies on this bench have existed, there would have been no question of any delays in such hearings full stop. This however, was not to be full stop. Yet, hopefully, the identical position of wiping out all delays at the Patna bench itself would be reached well within the next year full stop. However, there is no gainsaying the fact that as of today 1980 murder appeals only can be listed bracket open barring the specially ordered cases bracket close and heard in the ordinary course, and there thus remained a yawning gap of 3 years or more betwixt the filing of an appeal and its final disposal full stop. So long as this remains, and if it unfortunately recurs, the significant issues raised herein have to be considered and frontally faced full stop para. Mr. B. Narayani Singh, learned counsel for the petitioners, in an able argument at the very outset, pointed out that herein the issue of the grant of bail was plainly divisible in two clear-cut categories, full stop. Firstly, the grant of bail on merits, full stop. This would involve examination, whether the judgment indicates any inherent weakness on the merits of the case generally or against a particular appellant, and equally innumerable other considerations which enter into judicial scrutiny for the suspension of a sentence of a convicted accused, whilst his appeal is pending for disposal, full stop. This flows from section 389 CRPC, the merits of the case having been once considered under the aforesaid provision remain more or less a constant factor barring the addition of any exceptional factor thereafter, full stop. Entirely a class apart is, however, the second category where the issue of the grant of bail is on the ground of delay, and inherent limitations or inability of the Court of Appeal in hearing and disposing of the substantive appeal within a reasonable time full stop. Counsel highlighted that it is this latter and second category alone which primarily and solely calls for examination herein full stop. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.